tradition at Harvard Law School that immediately following the arguments and the opinions of the court, a reception is held in the multi-purpose room of the Pound Building. You're all invited to come and join in the festivities that we prepared at that time. Refreshments will be served. I'd like to start a new tradition at this time. In a few minutes, you'll most probably be meeting very closely the four oralists who are going to be presenting the case tonight. I think the oralists would be the first ones to admit, however, that a lot of the work they do, or the entire team effort, is something that you do with 6 people. Each of the Ames finals teams has 6 members. They've worked through the qualifying round, they've worked through the semifinal round against some very, very tough competition. And it's always been my feeling that they've never gotten the proper recognition that they deserve. So this time I'd like to introduce, if they would stand up and hold your applause to the end, counsel for the appellants. We have Robert Shapiro, Cass Sunstein, Stephanie Smith, and Winthrop Minor. We have the counsel for appellees, Joseph Sandler, Hugh Steyer, Mark Siegel, and Neil Beat. I think they deserve a large round of applause. This argument as much as possible. The judges have consented when they first come to the bench to sit for a few minutes. If anyone wants to take pictures, please take them at that time. Once the first oral argument begins, there will be absolutely no picture taking, flash or no flash. The clicking is very, very distracting to the oralists, and they need to concentrate as much as possible. For the same reasoning, we'd appreciate if you don't attempt to leave or come into the Moot courtroom during one of the oral arguments or attempt to move around. We will provide some ample opportunity in between oral arguments if you do have to leave or if you do have to move around. Please do it at those times with the breaks. That way we can all appreciate it. So on behalf of the Harvard Law School and the Board of Student Advisors, I'd like to welcome you all to the 66th Ames Moot Court Finalists, and I hope you enjoy the evening.
Is now in session. All persons having business before this court shall draw near and give their attention, and they shall be heard. God save the United States and this honorable court.
Tonight we hear number 77999. The West Bay Point New Freedom Church Incorporated et al. Versus Jonathan Barnes et al. We'll hear from the appellants. Ms. Curl.
May it please the court, my name is Sheila Kuehl, and along with my colleague John Pagan, I represent appellants, the West Bay Point New Freedom Church, a religious organization incorporated under the Statutes of Maine, the Reverend William P. Connell, pastor and founder of that church, and Ms. Susan Barnes, spiritual trainer for that church. The case is here on appeal from the Supreme Judicial Court of Maine. That court affirmed an order appointing Jonathan and Shaleen Barnes as guardian over their daughter Susan. I will argue that the decision of the Supreme Judicial Court of Maine should be reversed because, 1, it was issued on a finding of borderline mental illness based in great part on constitutionally impermissible evidence related to Susan Barnes' religious beliefs which are absolutely protected under the First Amendment. 2nd, that forced psychiatric treatment made possible by the order will impermissibly intrude on those beliefs in an attempt to alter them. Mr. Pagan will then address the ways in which the guardianship order interferes with religious conduct, both that of Susan Barnes and of the church, and that there exists no compelling state interest to justify that interference. He will also argue that the Maine guardianship statute is vague, both on its face and as applied. And I would ask to reserve 5 minutes for rebuttal. On October 24th, 1976, Jonathan and Shaleen Barnes saw their daughter Susan Barnes on the street in Bath, Maine. She was soliciting funds for the New Freedom Church, a faith that she had converted to over a year and a half prior. At the time when Jonathan and Shaleen Barnes saw their daughter, she was 18 years of age and thus an adult under the laws of Maine. Ms. Barnes tried to run away, but her father grabbed hold of her, forced her into the car, and took her to a medical center in Portland, where the parents requested that she be held for observation, lying about her age to the hospital personnel, indicating that she was 17 years of age and therefore a minor. A few days later, her attorney secured her release after furnishing proof that she was an adult being held against her will. Now, during the period of her detention, she was subjected to 5 intensive interviews and a series of hastily administered tests by Dr. Mary Mathewson, who had been asked by Susan's parents to interview her. A little over a week later, at the guardianship hearing, the testimony given by Dr. Mathewson, by Ms. Barnes, and by the Reverend Connell, the testimony relied upon by the court in issuing its guardianship order, revealed the basic beliefs, the basic tenets of the New Freedom Church, a faith to which Susan adheres. And I will show that it's the very elements of those beliefs that Dr. Mathewson used in forming her diagnosis, and which the court relied upon in denying Ms. Barnes' absolutely protected right under the Free Exercise Clause to the sanctity of her own thoughts. The basic doctrine, the New Freedom Church, is taken from a number of worldwide religions. They believe in universal brotherhood, the unity of the universe, that we're all children of God, that peace and happiness may be achieved through the teachings of the church, which are codified teachings. They believe that sacrifice is necessary and that one must cleanse the spirit before entering into the church. But more important to my point are 3 of the basic beliefs of the church that the psychiatrist relied on in forming her diagnosis of traumatic neurosis. The first is a belief that it is necessary to repudiate one's past, and in many cases, one's parents, who form a great part of that past. Dr. Mathewson said that that was highly significant in her findings, pointing specifically to a belief, and she used the word belief, that Ms. Barnes had no prior connection to her parents. She
Ms.
also
Kuehl, what is this other than facts?
Well, I'm trying to show, Your Honor, that the elements of the faith that Susan Barnes holds are the same elements that the doctor found to be part of her mental illness. And in judging that Susan Barnes' beliefs were indeed the mental illness, and later I will show in attempting to treat those beliefs as part of the mental illness.
First Amendment?
First Amendment.
Go ahead.
Thank you. Therefore, the first belief I think the doctor has relied upon is Susan's belief that she must repudiate her past. The second belief is obedience. Susan said that she feels that she must be obedient to God and to the Reverend Connell as his likeness on earth. Now, Dr. Mathewson said that a part of Susan's illness was the fact that she felt people should be dutiful and compliant. And I think it may be seen that if a concept like obedience may be characterized as thought control, then obedience to Reverend Connell as a belief of the church would be evaluated for the truth of that belief.
Do you say, Ms. Kuehl, on this record that this young woman is capable at this time of making an intelligent decision as to her religious affiliation?
Yes, Your Honor, we claim that she is.
You say the record permits that inference?
Well, the psychiatrist, Dr. Mathewson, indicated that Susan Barnes is suffering from a borderline traumatic neurosis. And the court then went on to assume from that she's incapable of making choices. In the record, the doctor indicated that she had treated 10 members of this church and other members of the new faiths, and that she found that they had difficulty in making choices.
Suppose this court should differ with you as to that point and decide that on this record we can't reach that conclusion and decide that she's incapable of making an intelligent decision. What do you argue then?
Well, then I would say that the the level at which we assume that a person can make a decision is set much too high in the case of First Amendment protected beliefs. That is, Susan voluntarily went originally to the church and chose the religion at that time. She was a mature minor at the time. There was no question about any form of mental illness. So that
Well, she made a choice before she was 18, didn't she?
Yes, Your Honor.
Well, was that mature?
Well, it would seem that it could be decided on a case-by-case basis. That is, in the area of minority rights, of the rights of minors.
I'm just
under a
worried
case
if you
like-
put it on the basis of mature and
Well,
then say that a minor has mature, I get in trouble.
Well, Your Honor, we believe that it's possible, and this court has found that it's possible for a minor to make a so-called mature choice. That is, the concept of the word mature and the content of the word
You mean
adult
like
are not
wearing
the
an
same.
armband?
Pardon me?
Like wearing an armband in the Tinker case.
Like in the Tinker case.
Well, that's a
Or
little
in-
bit different from joining a religion.
Well, but in Planned Parenthood, for instance, where it was found
Like
that a minor...
agreeing to an abortion.
Yes, Your Honor.
Minors can do that under the Supreme Court's rulings.
That's correct. In the Planned Parenthood case,
And parents can't keep them from doing it, can they?
no, they can't, because the Supreme Court in that case said that there may be no blanket parental consent and no
But
third-party
did the
absolute
court use the
veto.
word mature? That's all I'm asking. You know, to get another word other than mature.
Well, we would indicate then she was
And
a
for the
minor.
life of me, I don't know what the word is.
I suppose there may be a question about the content of the word mature. We would say then that she was a minor capable of making this decision. She was an intelligent 16-year-old. Her father testified that her grades were good. We would see no reason why she would be seen as incapable of making such a decision. And we would say then that she was also capable of adopting the beliefs of that faith, and that those beliefs must be absolutely protected. And even if she were, as Justice Hennessey indicated, if it were found now that she were not capable of making an informed decision to reaffirm her faith, a concept with which we would disagree, that having chosen the faith, if the court wishes to look at such a thing, that she deserves protection, just like any of us who maintain that we believe in a faith sincerely now. I think that the degree of her illness cannot be seen to be so great that she could not affirm her faith, that she could not hold it sincerely. And I think that what the doctor characterized as mental illness is nothing more than the elements of her beliefs. The doctor's analysis appears to be that based on Ms. Barnes' history, which she knew, and based on the description of what had happened to her, which she had heard and repeated to the court, and based on the tests which she analyzed in the light of that experience, her analysis is anyone who repudiates their past and obeys someone like the Reverend Connell must be unbalanced. And the court seemed to agree.
But that testimony was not in any way contradicted.
Dr. Mathewson was the only expert who testified. We are not saying that she was not correct in identifying elements of an illness in her capacity as an expert witness. What we are saying is that the elements she identified are absolutely protected beliefs. And therefore, the evidence is constitutionally impermissible.
But you're not trying to get us to out-psych the psychiatrist, are you?
No, I think that this court can
Because
accept...
I can't do it. And what I'm trying to get at is that you've got this record with undisputed testimony. And as I understand, what you're trying to get us to agree with you is that that testimony is really aimed at depriving this young woman of her First Amendment rights and not for the purpose of saying she's insane.
We don't claim bad faith on the part of the expert witness. We only claim that the elements of her diagnosis were the elements of Susan's belief, and that if they are absolutely protected, as this court has indicated they are, then that is constitutionally impermissible evidence. Because what value is it to protect something absolutely if judging them contrary to the clinical norms of society robs them of that protection?
And there was no testimony as to injuring anybody or being dangerous.
Quite the
As a matter of
opposite.
fact, the opposite.
Yes, and the court adopted that finding, that Susan was neither a danger to herself nor to any element of society that one could identify. But a second and independent ground for reversing the Supreme Judicial Court's decision is that the purpose of the forced psychiatric treatment is obviously to treat her illness. And as we just pointed out, that would mean treating her beliefs. The doctor means to force Ms. Barnes to re-examine, as she put it, the logic, in quotes, of those beliefs. And that is the purpose, and that they mean to give her psychiatric treatment is obvious because the court says that she should have it, the father says he would like her to have it, the doctor says she needs it. It's the primary reason for the guardianship.
But the Supreme Court, Judicial Court of Maine, says that this illness, and I'm reading, occurred because of the actions taken by the church. And continuing, treatment of that illness will help her regain that sense of self that is needed to resume responsibility for one's actions. In other words, this is a treatment that the court allowed in order to overcome what they felt was an imposition on Susan by the church. In other words, they want to exorcise the evil spirits introduced into this child by the church.
Exactly right, Justice Wright. And I think in assuming that they're evil spirits, it gets to the very heart of my argument. I think that the court seems to have forgotten, the Supreme Judicial Court, that this is really a case about religious belief. And in treating religious belief, in order to, what purpose could there be to treat the devils of this religious belief except to eradicate them? And we can't permit forced psychiatric treatment in order to overcome absolutely protected religious beliefs. And it's interesting, too, the way the psychiatrist indicated that she would treat it. She was asked by the court what the cure might consist of. And in one short answer, she uses the word stress 6 times. She says, wait upon further examination under what we've been calling stressful conditions, examinations which involve stress. As I said, the stress is on thinking, checking out logic. It's stress on the mind. A number of people subjected to this kind of stress find that their thinking has changed decidedly. And then she adds rather gratuitously, but it's not cruelty. Well, appellants
you rely solely on the First Amendment?
We rely, you mean on the First Amendment and the 14th Amendment?
You rely on the 14th Amendment also? Anything else in the Constitution that might help you?
Yeah.
There's probably a great deal in the Constitution that would help.
Ms. Gill, suppose this is purely hypothetical,
Yes, Your Honor.
but suppose you and I organize a group that's dedicated to a one purpose of smoking marijuana because our religion says we must smoke marijuana because our gods are named Mary and Warner. We set that up and we entice some other people to join with us in smoking, and we defend on the ground that 1, it is our religion, and 2, it's protected by the First Amendment, and 3, nobody's got anything to do with it.
Well, I would distinguish that, Your Honor, in several ways. First of all, I would say that if you believed that it was necessary to smoke marijuana, but you never smoked marijuana, that belief would be absolutely protected. That is, a person may hold beliefs in his mind or her mind and never act on them. And
But
the court should not.
My religion, you can't join it until you smoke.
Which brings me to my second point. Smoking marijuana would be conduct. Religious conduct is not absolutely protected, as Mr. Pagan will discuss in his section at much greater length, I think. The state may have a compelling interest to regulate that conduct. In this case, you're not only talking about religious conduct, but you're talking about illegal.
How do you establish that this is a religion? That's my point.
Well,
I mean, in the record that's here.
Well, the conscientious objector cases, it seems to me, had somewhat the same problem.
Segal?
We've looked at Seeger. Also, I guess the Woody case, which was a peyote case, there had to be some consideration as to whether
It was a conscientious belief.
whether it was a firmly held belief. I would say that one would have to look at whether or not there were other facets to this religion. But in the Seeger test, it's necessary to see whether this faith holds the kind of central place in your life that an orthodox belief in God would hold. And that would need to be adjudged in order to adjudge the sincerity of your religious thought. But the state might still have a compelling interest in keeping you, as it did with the Mormons who believed in polygamy, still have a compelling interest in keeping you from practicing that, especially if it's breaking the law, which was one of the considerations in the conscientious objector cases too. That is, they wanted a deferment and had to prove it was a religion.
And there was some peyote cases too, like my marijuana case.
Yes, but in the Woody case, they found that it was a sincerely held belief central to the religion, and found that it was okay.
Judge Wright led you some time ago to, he didn't say the magic words, but he led you somewhere toward Roe and Wade and Bellotti and Baird. Do you find any help in there that's
well,
not exactly the First Amendment, not exactly the 14th Amendment, or maybe all combined?
Well, we would say that in those cases, especially the Bellotti case, which involved a minor, that there may be some reason to try to judge whether or not someone can make a sincere or a good decision, or whether or not they need some consultation from their parents. But in the case of privacy, I mean, the right to privacy doesn't have the same kind of absolute protection as the right to religious belief. And I hope that you'll separate that I'm talking here about belief only and not about religious conduct.
When you get to putting degrees on the First Amendment, you're going to get in more trouble than you will ever get out of.
Well, Your Honor, it seems that this court, with all due respect, has
Is
said...
in that problem.
Is in that problem. Naturally, as you might expect, we think that it's a very good idea to protect religious belief, absolutely, and not only because we happen to be representing appellants, but because in a 200-year history, it's been one of the basic tenets that an American may hold a thought without the government intruding in that thought. And we would hate to see this court back down from any concept of absoluteness like that. We would say that the forced psychiatric treatment to Susan Barnes would be impossible if this court were to fashion an order, if it were even possible for this court to fashion an order, that the psychiatrist could treat Susan Barnes as long as she didn't touch her beliefs, because the beliefs are so inextricably bound up in the elements of the illness that it would be, and psychiatry is such a young and inexact science, it would seem impossible for Dr. Mathewson to walk around Susan's beliefs somewhat like a cat in a china cupboard and try to cure or treat only those facets of the illness that had no relationship to Susan's beliefs. Even if Susan were to hold out for 6 months or more, and the doctor said it would take 6 months or more, Susan would have been put to the proof of her religion. She would have been forced to choose her religion twice. And we feel that under the circumstances that would be impermissible, and that this court should reverse the decision of the Supreme Judicial Court of Maine and dismiss the guardianship decree. My time is up.
Thank you, Ms. Kill. Mr. Vagueness.
May it please the court. My name is John Pagan. We contend that the guardianship order substantially burdens the free exercise of appellant's religious conduct. Forced psychiatric treatment will isolate Ms. Barnes from other members of her church for a period of up to 6 months or more. It will interfere with her right of association, and it will prevent her from participating in group religious activities such as chanting and studying church doctrine together, and it will also interfere with her evangelistic duties. Now, these aren't merely activities that are just permitted by the New Freedom Church. They're required by it. They're at the very core of her faith.
You used the term substantially interfere with the appellant's rights. Was that apostrophe S or S apostrophe?
S apostrophe, Your Honor. Because we can...
How do you justify the church and the minister being here at all?
Your Honor, we believe the order will deprive the church of Ms. Barnes' services for a period of up to 6 months or more. Now, the church has invested almost 2 years training Ms. Barnes to become, she is in effect the assistant pastor of the church. She's in charge of training new converts.
And the church will lose money?
No, Your Honor, it will lose her services in spreading the message of the church.
And raising money.
And raising money too, yes, Your Honor.
Now I understand. But I don't understand how that gives this court jurisdiction.
We think the
in
money...
protecting the moneyed interest of a church.
Your Honor, it isn't just money. It isn't just money at all. The central purpose of this church is to get away from money. It's an anti-materialistic church.
And that's why they send people out to raise money. So if you get enough, you can get away from it.
They take the money, Your Honor, and use it to fly members of the church to various cities where they can proselytize and recruit new members. Now, it's essential to the growth and development of this church that it win new converts. That's what they use the money for. And Ms. Barnes plays a key role in this evangelistic process. And if she's taken away from them for 6 months, the church is going to suffer immediate and direct and very substantial injury. We think that gives the church and Reverend Connell standing, and we think that it also gives them a very substantial stake in this litigation.
Judged by tests of strict scrutiny and compelling state interest?
Yes, Your Honor, because
First Amendment right?
Yes, Your Honor, because it interferes with their religious conduct. It will also, we think, and certainly this was the assumption of the Supreme Judicial Court, cause them to alter their training program. In fact, the Supreme Judicial Court said one of the reasons we're granting this guardianship is because we want to let the church know it can't use the type of training techniques it used in this case. It was intended to have an in terrorem effect, and we submit that it will have an in terrorem effect. The church's rights will be chilled, and it may in fact refrain from using what it considers to be the best training program for its members.
How is Susan going to be held while she's being treated by the psychiatrist so that she can repudiate her religion? In other words, the guardianship order does not require a commitment of any kind.
I think it amounts to de facto commitment, Your Honor, because Dr. Mathewson testified that it would be, for the treatment to be effective, it had to be conducted in isolation from all, in her words, I believe, were controlling agencies and persons, clearly the church. They have to keep her away from the church. Ms. Barnes testified that they will have to lock her up before they can administer psychotherapy. She said...
She was used to being locked up because one of the appellants had her locked up, didn't they?
Your Honor,
didn't the church have her locked up?
We think that, well, the court below did find that the door was locked during part of her training. However, Your Honor, that is not the same thing as saying that she was restrained or held against her will. Now, certainly, if one...
Being locked up is not restraint.
No, Your Honor, because
well,
I think...
What is it?
Well, in this case, it was a device to increase...
I mean, when you're put in jail, you're locked up. That is not restraint.
Your Honor, under the tort law, if a person consents to give up his freedom of movement...
Then where is her consent here?
By joining the church, having been advised that she would have to lead a monastic life, undergo a period of instruction...
And the monastic life was the period when she was living with a man?
The monastic life was her initial...
Is that
monastic
monastic?
life was her
Is that
initial
monastic?
training program. Within the meaning of this church, Your
Honor.
But, Your Honor, Reverend Connell testified, and his testimony was uncontradicted, that Ms. Barnes was free to leave at any time. All she had to do...
It was open the door that was locked.
...was say the word. No, Your Honor. With respect, Your Honor, the court did not find that she was ever restrained against her will. She could have asked to leave at any time and it would have been allowed. Reverend Connell testified that the reason for this type of training program was in order for her to get to know herself, to concentrate, free from distractions. And the door was locked to prevent her from being interrupted during her meditation period. But there is no evidence in the record to indicate that she couldn't have left at any time.
And that's what the psychiatrist wants to do now. He wants to lock her up
Exactly,
and change her back.
Exactly, Your Honor. The type of coercive persuasion engaged in by the church was close to the type of coercive persuasion used by all monastic groups. Edgar Schein, who coined the term coercive persuasion, states that the Benedictines, the Dominicans, law professors in the Socratic dialogue, revivalists, all engage in forms of coercive persuasion. But what distinguishes that kind of coercive persuasion from the kind of coercive persuasion used by the North Vietnamese and the Communist Chinese is that in the instance of the monastic orders and in the Socratic dialogue, the person voluntarily submits himself to the coercive process. Now, we contend that that is the case here. But there are parties in this case, Your Honor, who do plan to use the type of coercive persuasion which the state does have a compelling interest in preventing. And their names aren't Reverend Connell in the New Freedom Church. Their names are Jonathan and Shaleen Barnes.
Does it make any difference that at the time of this consensual lockup that she was 16? She was a minor?
No, Your Honor, it doesn't make any difference because she was an intelligent minor. She was acting on the basis of adequate information that she would have this period of instruction, that she had to sever her ties with her parents, that she'd lead a monastic life. She spent at least 3 or more months contemplating this decision before she made it. This was no spur-of-the-moment thing.
Would it make any difference if she was 14?
Well, Your Honor, in the Chatwin case, which involved a 15-year-old who this court held to be capable of giving intelligent consent to the religious doctrine of celestial marriage, the court said a 15-year-old can do it. The presumption of incapacity arises only when it is a child of under 14. So we think on the basis of the Chatwin case, which was grounded upon the common law, that certainly a person age 16 can give informed consent, and we think Planned Parenthood indicates that. We think Bilotti indicates that. So it's our contention that the state has a compelling interest, does not have a compelling interest in this case, either on the grounds of traumatic neurosis, which is a parens patriae interest, or on the grounds of coercive persuasion. Now, the court below found Ms. Barnes has a borderline traumatic neurosis. Now, borderline means that she's perfectly normal much of the time. And during the rest of the time, she just simply seems rather odd or different. But of course she's different if you use as your yardstick, as the court below did, the clinical norms of secular society. Because here is a person who has turned her back on secular society. She has rejected the material world. And yet they compare her to doctors and lawyers and other people, non-monastic people. As compared to them, of course her values are abnormal. But Dr. Mathewson testified that Buddhist monks who undergo a similar training program to Ms. Barnes are also mentally ill. She seems to share Freud's view that all devoutly religious people must be neurotic. But I think this shows a startling insensitivity to First Amendment values. Because the First Amendment wasn't meant to protect only those of us who can get psychiatrists to testify that we're 100% normal. In fact, the First Amendment was meant to give breathing space, to protect the right to be different, so long as you don't endanger anyone. And to take away someone's religious liberty simply because she's odd or different, I think flies in the face of what this court said in Wisconsin against Yoder, that a way of life that is odd or even erratic, but which interferes with no rights or interests of others, is not to be condemned merely because it's different.
It was the right of the Amish to teach their own children, wasn't it?
The right of the Amish and their children to be protected against intrusion by the state.
Which is a little different from this case.
That's right, Your Honor. This court expressly...
It could be said that that was protecting the parents' right.
And the children, because
the
majority found that there was no conflict of interest in that case between parents and children. But the court reserved the question of what happens when those two do come in conflict, as it has in this case. Now, in this case, we have really 2 adults. We have an 18-year-old young woman, and we have her parents.
Now, we've been talking about a 16-year-old one before.
Your Honor, I think the rights are to be adjudged as of today.
All that I see in this case was all these things she did before she was 18.
But, Your Honor, the question is...
She left home before she was 18.
Yes, Your Honor, but the question is...
And she got rid of her parents before she was 18.
But the remedy is...
And she went out getting money before she was 18.
Yes, Your Honor.
Could it be that if her parents drove her out, by the way they treated her? In other words, obviously the parents lost contact with this young woman. Otherwise, she wouldn't be looking for some help in other directions.
Well,
is that possible?
She called them... It's possible that they did. The conflict in values between parents and daughter or what was responsible for her departure. But to return to your question, Mr. Justice Marshall, what I think is the crucial question in this case is the remedy. Because we're not talking about taking away the liberty of a 16-year-old. We're talking about taking away the liberty of an 18-year-old, of an adult, who is, under the laws of Maine, an adult for all purposes. This guardianship action was brought after her 18th birthday. The psychiatric treatment will be imposed after she has attained adult status. So we think, from a constitutional standpoint, it makes absolutely no difference what happened before. Because you have before you an adult with the same rights under the First Amendment as her parents. And there is no basis for giving one greater priority than the other.
Suppose this court should draw from this record the inescapable inference that she's incapable of making an intelligent decision as an adult, 18 years and 1 month. What's your argument that some way we can make this problem retroactive till back to 16? Is that your argument?
Well, we believe as to the question of religious beliefs, it doesn't matter whether she's rational or not today. It doesn't matter if she's sane or insane. Those beliefs are absolutely protected. Now, as to her religious conduct, we contend that forced treatment cannot be imposed upon her merely on the basis that she has a borderline neurosis, the condition on the mental health continuum closest to normality.
But where would you put the test in words where the state might intervene?
Only when a person is dangerous to someone else or very, very dangerous to herself, life itself being at stake. Short of that, the state does not have a compelling interest to interfere with religious conduct. That is our position, but the court does not have to go that far in order to decide this case. Because I think the court could decide this case on the basis the Second Circuit did in Winters against Miller and hold that a person who is not dangerous to anyone and has not been judicially found incompetent has a First Amendment right to refuse treatment. Ms. Barnes has not been found incompetent by any court. Ms. Barnes has simply been found to suffer from a borderline neurosis.
May I understand you correctly? It isn't assumed that after this treatment there will be a hearing?
I don't know. There will be to dismiss the guardianship.
If not, why have the treatment at all?
I'm not sure I understand your question, Your Honor.
You say, isn't it inevitable in this case that at some time there will be a determination as to whether this young lady is to be declared or not declared?
I don't think that there will be a hearing on her competency.
You don't?
At any point. No, Your Honor.
Well, why treat her?
It's a very good question because she is not incompetent. She has an anxiety state. And yet the court below found that sufficient grounds. That was the compelling interest which outweighs her First Amendment interest. That was sufficient to send her away from the people she loves most and the work to which she has devoted her life for up to half a year or more. There's been no incompetency hearing. If there had been, it would have been brought under subsection 1 of the
Well, this is a half
Act.
year. How long was she away from her parent?
Almost 2 years, Your Honor.
That was all right.
Because she consented
But
to
to
it.
keep her half a year away from Reverend news as much as, that's different.
Yes, Your Honor, it is different because she does not consent to that. It's not simply a matter of time, it's a matter of consent. It's a matter of voluntariness. The church didn't imprison Ms. Barnes, but Ms. Barnes' parents did. They abducted her on the streets of Bath, Maine. They dragged her into a car. They took her against her will to a hospital where they held her there for 3 days until her lawyer came and furnished proof that she was an adult being held against her will. And then now, acting under color of authority of the state of Maine, they're going to do the same thing to her. They will have to lock her up. Only they won't limit it to 3 days. They'll limit it to 6 months and maybe even longer. And this time they do have the imprimatur of the court itself.
No, but she has an indefinite sentence at the moment.
Yes, Your Honor. And as far as we can tell, it's just totally on the say-so of the psychiatrist. And we think this raises really one of the fundamental questions in this case, is whether psychiatrists should be given the power to determine the scope of religious liberty. And we think that
The psychiatrist does have the power to testify that you're sane or insane.
subject to very strict judicial
Yeah,
guidelines.
Right, like in my state of Maryland, where any 3 physicians, including 3 obstetricians, can testify that you're insane and away you go.
I think that's an unconscionable law, Your Honor. And a law which ought to be unconstitutional and would be unconstitutional if this court adopts the view which we're advocating. And that is that need for treatment alone can't suffice to deprive someone of their liberty. And some of the 3 judge courts, I think there have been at least 3 so far. One of them, Stamos v. Leonhardt, which is cited by both parties in their briefs, recently held that a person cannot be involuntarily civilly committed on the basis just of a need for treatment.
How about the Katz case?
And I beg your pardon?
Katz, K-A-T-Z.
The California Court of Appeal case?
Mm-hmm.
That was decided on partly on vagueness grounds and partly on First Amendment grounds. There, a conservatorship, similar to the Maine guardianship, was resorted to by parents to regain control of their adult children. The Court of Appeal of California struck down that law. One of the reasons it gave was that it was void for vagueness, and we contend that the Maine guardianship statute is also
That wasn't the
void for
main
vagueness.
reason.
The
The
other
main reason was First Amendment, wasn't
Yes, Your Honor, it infringed the First Amendment liberties of the young people there. And one of the rationale was that adults are equal under the law, and that there is no basis for allowing parents to, in effect, extend the umbilical cord to the grave, to say that you have parental rights beyond the age of majority, and that parents can continue to control their children, control their values. We have a clash in values here in this case, because Jonathan Barnes has testified that he thinks his daughter is throwing her life away. This is a question of values, and the courts of Maine have agreed with the father. They have said that anybody who chooses to spend her life with this new faith must be crazy. It must be crazy to reject middle-class values and substitute for them something that, rather than working for personal gain, you devote yourself exclusively to serving your God.
You argue that you mentioned that in your brief mentions, that the statute upon which the probate court relied is void for vagueness.
Yes, Your Honor.
Is it necessary for the probate court to rely on any statute? Doesn't a probate court or a family court have common law powers in most jurisdictions to intervene on behalf of incompetence?
Well, it may to intervene on behalf of incompetence, but this is not an incompetency case. There's been no allegation that she's incompetent. Had there been such an allegation, it would have been brought under Section 1 of the Act, which pertains to people who are incompetent, mentally ill, or of unsound mind. This was brought under Section 4 of the Act, which pertains purely to people who have been victims of coercive persuasion and are likely to be imposed upon by artful or designing persons. It was the latter phrase, likely to be imposed upon by artful or designing persons, that was struck down as void for vagueness by the California court in the Katz case.
Do you think, suppose this court should find that this is the equivalent of as far as your clients are concerned, the equivalent of a hardcore case, do you think you're entitled to argue void for vagueness under those circumstances? But the circumstances, suppose we found that the circumstances are so compelling here, so to be held against your clients, that they must have been on notice that they were violating the statute, even though somebody else might have had doubts. What do you say to that?
Your Honor, I don't think it would have been possible, because they did here what Benedictine abbots do, what Dominican abbots do. They subjected someone with their permission to an intense and rigorous and highly disciplined program of religious instruction. They had no more way of knowing that the type of coercive persuasion at issue in this statute applied to them than would the abbot of any well-established religion. Because the word coercive persuasion is an amorphous grab bag. It covers everything from the POW situations to a pushy door-to-door salesman. It's just, the term is so broad as to be virtually meaningless. Now, the appellees contend that in this case the court construed it more narrowly, but we submit that they did not, and that the appellants had no way of knowing what they did was illegal. I thank the court for its kind attention and ask you to reverse the decision of the court below.
Thank you, Mr. Pagan. You may proceed.
May it please the court. My name is Jonathan Scher, and along with my co-counsel, Mark Gottridge, I am here today to represent the appellees in this action, Jonathan and Shaleen Barnes. Jonathan and Shaleen Barnes are here today to vindicate the power of the state of Maine to provide a guardian for victims of coercive persuasion. Appellees are here also to ensure that no exception is made to the application of a statute providing for such a guardianship when religious beliefs, the basis for the claimed exception, are not the product of the claimant's own free mind and will. Further, appellees are here to ensure that no such exception is made when the state interests served by such a guardianship are sufficient on balance to justify an incidental burden on religious practices. I will argue that the coercive persuasion subsection of the Maine Adult Guardianship Statute is not void for vagueness, and further, that Susan Barnes's protestations of religious belief do not warrant the protection of the First Amendment. Mr. Gottridge will then argue that the state of Maine, acting as parens patriae to protect Susan's welfare, and acting under the police power to protect the welfare of society, has interests of sufficient weight and importance to require that no exception to the guardianship statute be made in this case. As applied by the court below, the coercive persuasion subsection of the Maine Adult Guardianship Statute is not void for vagueness. Now, as would a probate court in future applications of the statute, we look to the only decision that has applied Section 36014, the opinion of the court below. The bare words of the statute are not now and can never be before this court, for an interpretation of the statute having been made by the highest state court. This statute must be considered as if it read exactly as it was interpreted by the state court. Nor is our attention limited to holdings, specifically called holdings. Instead, we look to the opinion as a whole to see how the authoritative interpreter of state law has analyzed the statute's proper application. This inquiry will show that standards have been set to limit a probate court in the exercise of its discretion, and that fair notice of the scope of the statute has been given. Because as applied by the Supreme Judicial Court, Section 36014 requires first that the prospective ward have been subjected to coercive persuasion. Second, that the prospective ward now be suffering from a traumatic neurosis. And third, that the prospective ward's mental condition be the result of an effort to force compliant behavior. Now, these three standards...
The statute says that this person may...
Noted below was that Susan Barnes has now, because of the trauma, certain unconscious reactions. So, for example, the doctor said that she was blocking. Now, this does not mean that Susan is making a simple volitional decision not to consider, for example, as the doctor pointed out, her parents or her past. It's a psychiatric term of art. It refers to a person who simply is unable to remember the past. What the doctor was pointing to is a form of psychological amnesia that can be caused by a traumatic neurosis. Because what happens in a traumatic neurosis is that one cannot cope consciously with a situation of extreme stress. Now, the diagnosis of traumatic neurosis and the treatment appropriate for one who suffers from a traumatic neurosis is described in a technical literature, in a medical literature, that does provide a sufficient guide for the exercise of a probate court's discretion.
But Ms. Kuhl argued that when we get the time and opportunity to add up this record, that this doctor will have based her diagnosis on a summing up of the tenets of the religion involved. Do you agree with that?
No, I do not. Adamantly disagree. The witness below and the court below were clear and certain that what they were doing is not looking to see whether Susan Barnes is obedient to the dictates of the church. but to see why she is obedient. They recognized that she could be obedient either because of sincere religious belief or because she had been put through coercive persuasion such that she should no longer make a choice as to whether or not to be obedient. And the court below held, they found, that she was obedient because of coercive persuasion.
Do you think that this case would have been the same if it involved some other established religion?
Yes and no.
Take your choice.
For the first minute, I'll take yes, and for the second minute, no. It would have been the same in the sense that the same legal tests would have been applied to see whether Susan Barnes fell within the scope of the statute. But we know of no...
Do you know of any such case?
No. This is the first time that this statute has been applied. But we know of no similar religious group that practices a regime of coercion anything like the West Bay Point New Freedom Church. It is simply incorrect to say that what Susan went through is the same as what a Dominican or a Benedictine goes through in their novitiate. It's factually incorrect. For example, they are allowed to see their parents, they are encouraged to live with each other, and indeed recognizing that even though the regime...
I don't see how you can say this never happened before. Well, it happened in the Katz case out in California.
Your Honor, in the Katz case, we did not have a statute that dealt specifically with coercive persuasion. Instead, the statute had only the requirement that a person be likely to be imposed upon by artful or designing persons. But it did not focus the court's attention on the techniques of coercive persuasion. Now, it is our understanding that certain testimony with regard to coercive persuasion was considered by the Katz court. But we did not there have the tripartite requirement, the act requirement, the effect requirement, and the causation requirement, that there be coercive persuasion or resulting traumatic neurosis. In summary...
Are you interfering with this adult citizen's right to exercise her First Amendment rights?
Your Honor, we argue that her statements of belief do not warrant the protection of the First Amendment. But
why not?
It's a complicated argument, and it'll probably take some time. If I may first make two additional points about the question of vagueness, then turn to it. The first point is that the fact that 36014 has sufficient standards now incorporated in it to guide the discretion of the probate court is sufficient to answer any problem of notice if problem of fair notice was presented by this case. But since the statute looks to the status of the prospective ward and to the actions of other people, it can't be said that this is a statute that relates to the conduct of the prospective ward. But to move directly to the question of whether her beliefs warrant the protection of the First Amendment, Susan and the Church do claim that an exception should be made to the application of the guardianship statute in her case because the statute will impermissibly interfere with practices that they say are required by religious scruples.
If a mental illness is oriented principally to religious belief, is the state always precluded from interfering?
No, Your Honor. But this is not a mental illness that relates directly to religious beliefs. Instead, it's not the content of beliefs. It's not the truth or falsity of the tenets of the church.
Where do you get the mental illness? I thought she was on the verge of something.
No, Your Honor. A borderline traumatic neurosis is a traumatic neurosis whose symptoms are episodic. Consider the following case. A person is
No, I'm considering this case. Is there a finding here that she's incompetent?
There is a finding by the court below that she is incapable of making certain choices.
My question was there a finding of incompetency? And the answer is yes or no.
The answer, Your Honor, is no, in the sense that there was...
Well, then by what right do you have to commit her?
Your Honor, she is not being committed.
Same as...
No, Your Honor.
Isn't she to be subjected to treatment?
She is to be subjected to treatment.
For a period of 6 months?
And who's going to hold her while
6
she's
months.
being treated? She's got to be held. This woman doesn't want to stay around to let the psychiatrist treat her. She wants to go back to her church. So she's got to be restrained. So I think it's not completely candid to suggest that she's not being restrained. And further than that, I'm concerned about the fact that this is an indefinite sentence practically at the whim of a psychiatrist.
To treat the questions in reverse order, it is not an indefinite sentence. For if there is ever an occasion where it appears that either she has been cured or the cure will not work, either she refuses to submit to the treatment or she's adamant or in fact these beliefs are not the product of coercive persuasion, her attorneys can move under Section 3607 to have the guardianship dismissed.
Is there any way for her to do it without leaving the church?
Your Honor, there is unfortunately no way that she can gain the necessary treatment without being separated from those individuals who are now...
And I thought you said a minute ago that it wasn't tied up with the church, the psychiatrist, and now you admit that it is.
Your Honor, the treatment has to be...
You admit that it is, don't you?
Your Honor, the treatment has to be done separated from those people who have
But
exercised.
the treatment is to get her out of the church.
Yes, so that she can undergo treatment.
And you don't have any First Amendment problems with getting somebody out of a church.
Your Honor,
Well, getting somebody out of a religion, since church is not in the First Amendment.
Your Honor, our argument is two-part. The first part is that her statements of belief do not warrant the protection of the First Amendment because they are not what this court should consider to be sincere or truly held. Now,
You mean this is not a religion?
this is a religion. We do not question the fact that the West Bay Point New Freedom Church is a religion. But the question is whether Susan's affirmations of belief do warrant the protection of the First Amendment. Because the purpose of the First Amendment is to ensure that there's no collision between beliefs and the law. But if this is not a case where we are dealing with sincere religious beliefs, there is no such collision. For example, in the Seeger case, it was questioned whether the opinions of the statements of belief of a person who goes before a draft board warrant the protection of the First Amendment when the person who is before the draft board is lying. And it was indicated that because the person does not have a sincere commitment to those beliefs, they would not be given the protections of the First Amendment. Now, what we claim is that because Susan's present statements of belief resulted from coercive persuasion, they similarly do not warrant the protection of the First Amendment. Now, we don't claim that Susan is lying, but we do think that when a person is put through the ordeal that Susan was put through, when a person is put through coercive persuasion, they can be made to say things without ever considering whether what they say is personally meaningful to them. Instead, they say things because they're told to say things, and they act because they are told to act.
In this line of argument in your brief, counsel, you compared the belief here, or the thing that you deny is a First Amendment problem, you compared it to a coerced confession, which must be excluded. I read the brief as to that section 3 times. I didn't understand it. What's the analogy?
Our point is that we are trying to draw we're moving into a new area of the law here because there's never before been a claim that coercive persuasion denies the sincerity necessary to bring a First Amendment claim. And in this new area, we look to previous decisions of the court to indicate what are the effects of psychological coercion. And this court has held in previous decisions that certain of the elements of psychological coercion that are clearly present in this case are sufficient to require that a confession gained under those circumstances would be considered involuntary. But all that we are trying to show is that this court has recognized that sophisticated methods of persuasion can be as effective as the rack and the thumbscrew in taking a person and making them make affirmations of belief that they do not in fact hold as a sincerely meaningful belief.
Must Susan come in and prove that she made a free choice? Is there a burden of proof on her with respect to her First Amendment rights?
The burden of proof on the question of sincerity is clearly on those people who are forwarding the interests of the state. And we think that we have met that burden. Because when a person is put through coercive persuasion, it's not important to them when they make their statements of belief that the beliefs are what they would consider for reasons of religion to be true or false.
The state says that whenever you are coerced into this religion, the state has a right to deny that religion to you.
The state has a sufficient interest to warrant that there be given treatment to cure the disease. Yes.
And the disease is the religion.
The disease is not the religion. The
Well,
disease
what
is
is
not,
it?
The disease is not the tenets of the religion. The disease is caused by something that the church does to a person.
Well, there's something that the religion does to the person.
Yes. But the
And
actions...
so you have to get rid of what was done to the person, which is religion,
But, Your Honor,
which is First Amendment.
true, but the First
Do I need to
Amendment...
go any further? Which is?
The First Amendment is not absolute.
It's
If
not
this-
applicable.
Absolute. Absolute. Instead...
Why not?
Because under the previous decisions of this court, if this court does hold, in fact, that Susan Barnes
Well,
is...
I think there's a little difference between what was shown in this religion and polygamy.
Your
you
Honor,
want to go with any of the other ones while you're at it?
there is a difference between polygamy and
Well,
coercive.
is there any charge that there's something wrong with this religion?
Not with the religion, only
Well,
with
what is it that's wrong with this religion?
the practice of coercive persuasion.
Now, anybody that is allegedly persuaded against his will can be relieved from his religious responsibilities.
Not when they are
I'm
merely...
trying to set a precedent for the future now,
The,
so that when you come up as a child and all you ever hear is that you go to religion A, and you get that from your first word up until you're 18. It could be coercion, couldn't it?
not coercive persuasion.
Well,
Perhaps-
the parents lock you up in a room and give you books on this religion and tell you to read this religion and go outside and raise money for this religion, etc., etc., etc. Then the state comes in and says, you must be relieved of this religion. You don't want to set that as a general principle now, do you?
No, and it would not be
Oh.
under the statute as interpreted by the court below, because what you do not have there is a concentrated effort to force a change in belief such that an expert witness would call it coercive persuasion.
Well, suppose the expert witness said that what the parents did was coercive.
There is a world of difference
Well,
between...
suppose the witness testified. Suppose the same psychiatrist testified.
Your Honor, if it was found to be coercive persuasion, and if you show, which I'm not trying to hint that you do, the signs of a traumatic neurosis, then in fact, and if there's a causal link between the two, then in fact the statute would operate.
And that goes against any religion?
Any religion, any group. The statute itself does not deal with religion. The statute deals with the problem of coercive persuasion.
Well, not only would the legislature have to leave town, but the court would too. Wouldn't it?
No, Your Honor, because there is a clear definition in the relevant psychological and psychiatric literature that a probate court can look to for a definition of the terms coercive persuasion and traumatic neurosis.
Well, are you saying that parents can't coerce?
I've never come across two parents who would lock their daughter into a room, subject them to forceful interrogation until her will was broken.
But
So
suppose you did find one.
if that did happen, then in fact they would be subject, the ward would be subject to the guardianship.
Well, my final question, you don't have to go that far to win this, do you?
No. Your Honor, we should look to what is the practical effect of requiring that Susan's beliefs be sincere. First, by denying an exception to the application of the guardianship statute, we do not consider whether her beliefs are true, but only whether they are truly held. What is required is an objective inquiry into Susan's commitment to the beliefs that she proclaims. This inquiry requires no judgment of this court, any other court, any tribunal, as to whether the church's tenets are true or false. Further, It does not matter whether the church's tenets are orthodox or unusual, because, as was just discussed, this statute does not discriminate amongst religious groups, and any religious group that has the coercive regime of the West Bay Point New Freedom Church may be subject to a guardianship. Your Honor, because this
Mr. Chair, before you move on with that, your opponents stated that only one doctor testified in the probate court. Is that correct?
Yes, that is correct.
I see not only your brief, but your opponent's brief sprinkled with quotes from various psychiatric texts. For instance, there's one here by an S. Freud. Did he testify before the... Did he testify before the probate court?
No, Your Honor, but the presence...
By what rule of court do you or your opponents insert all these quotations from textbooks? Were the textbooks received at the probate court?
No, Your Honor, but the presence of Justice Brandeis is so powerful at this school that we felt that we could put in what could be taken in under judicial notice.
I heard an eminent psychiatrist say not too long ago that Freud's teachings were a lot of hogwash. Should we reject your brief on that account?
No, Your Honor, you should not, because the question as to whether or not there should be a statute governing coercive persuasion is one that has been settled by the Maine legislature. We are not here to decide whether one psychiatric group is right or wrong, nor are we here to sit as a board of psychiatric review to state whether the findings of the court below were accurate. What we are here to do is to try to make the best job we can of applying this statute. Now, looking to the statute itself, we contend that because Susan Barnes's statements of religious belief were not sincere, should not be considered sincere by this court, the application of the statute does not violate the First Amendment. Indeed, this threshold question stands as a guard to ensure that the First Amendment serves its intended purpose of protecting the free exercise of religion, because the Free Exercise Clause must not be allowed to become a tool for perpetuating the effects of coercion. Susan's beliefs were coerced, and because of that, they do not warrant the protection of the First Amendment. But this is not the only reason why the First Amendment does not require that an exception be made to the application of this statute. For even if we assume, for the purposes of argument, that Susan's statements of belief do warrant the protection of the First Amendment, the state of Maine has interest sufficient to justify any incidental burden on religious practices. And to explain that, if there are no further questions of this court on either the questions of sincerity or on the vagueness venant of the statute, I will turn to Mr. Godridge.
Thank you, Mr. Chair. Mr. Mark Godridge.
Thank you, Your Honor. May it please the court. My name is Mark Godridge, and along with Mr. Schuer, I represent the appellees Jonathan and Shaleen Barnes. If indeed the protections of the First Amendment do extend to the beliefs and practices of Susan Barnes, the question is whether the state of Maine is required by the First Amendment to make an exception to the application of its adult guardianship statute in this case. It is our position that the court below was correct in refusing to make such an exception, because the important state interests, which are furthered by the appointment of the appellees as guardians of their daughter, are of sufficient weight and magnitude to justify the resulting limited and indirect burdens upon the religious practices of the appellants. It should be noted first, there is really no question of this guardianship interfering with the religious beliefs of the appellants. There is no evidence whatever that it was the purpose of the guardianship to interfere in any way with those beliefs of Susan Barnes.
Where did you get that from? Is it true that the sole purpose for the guardianship is the religion?
There is nothing in the record to support that contention, Your Honor. On the contrary, the only thing...
Well, what else is there in the record other than the religion?
Well, there is the testimony of...
What other than religion is in the record?
There is the testimony that the purpose of the guardianship by the proposed guardian, Jonathan Barnes, is to give Susan Barnes medical treatment which will give her the ability, an ability which she now lacks, to make a meaningful choice with her life.
As to religion?
As to all sorts of matters, Your Honor.
Like what? Now stick to the record. Like what?
Well, it is true
other than religion.
It is true that the record is concerned largely with religion, but...
No, I will not let you go with that. Isn't it true that there's nothing in the record but religion?
There is definitely there is 99 and 44/100% religion.
I'll settle for it. I'll settle for it.
However, as for the other 56/100%, Your Honor, there are many things indeed in which people make meaningful choices in their own lives. And Susan Barnes now possesses not only lacks the capacity to make a choice about her religion, but to make decisions based upon reason. That was a finding of the probate court, which should not be overturned in the absence of any clear error. Now, Susan Barnes' guardianship will not in any way interfere with her religious beliefs, because during the term of the guardianship, there is no evidence at all that she will be forced to believe anything other than she now believes.
Well, a lot of people go around doing dumb things, but as long as they're not hurting themselves or hurting somebody else, what right has the state to intervene?
Well, the state has a very strong interest, Your Honor, as parents patriae, with the health and welfare, both mental and physical health, of persons who are not capable of properly caring for themselves. Susan Barnes is such a person. As such, she is a proper subject of the state's concern as parents patriae. As a result of the actions which were taken by the New Freedom Church, Susan Barnes is, in the words of the Supreme Judicial Court of Maine, incapable of possessing the capacity to make a meaningful choice with her life. She is in a very bad way mentally. She is suffering from a severe personality disorder which prevents her from having the capacity to look back at things in her own past, to look forward to things in her future.
But she says she has a right to be let alone and to do dumb things if she wants to. What do you say to that?
This is not a matter of dumb things. This is a matter of a clinically identifiable and clinically found mental illness, which is of sufficient magnitude to warrant the interest of the state as parents patriae in providing a mechanism whereby Susan Barnes' loving and caring parents may step forward and volunteer their services to provide for Susan Barnes.
They did, by yanking her off the street. Against their will, and offer them their love and tender care. Is that right? Is that what the record shows?
The record shows that her parents, acting out of somewhat excessive zeal, may have indeed acted a little bit propitiously in that case, but we are dealing here.
And she was an adult.
And she was an adult. But now she is an adult who is subject to the adult guardianship statute.
Is there any
of Maine.
danger of her hurting anybody?
Excuse me, Your Honor?
Is there any danger of her hurting anybody?
There is no danger of her
Well, what is the
actually...
interest of the state if she's not hurting anybody?
Well, there's no indication...
The interest of the state is that if she doesn't participate in some religion approved by the state has an interest to put a guardian over her.
Well, there was no interest...
Isn't that the interest, really?
No, the interest...
Wrong religion?
That is not the interest of the state in this case. The interest is in a mental illness which has caused Susan Barnes to be incapable...
But it's not hurting anybody.
Well, the girl in Prince v. Massachusetts was not hurting anybody either, Your Honor. But the state...
Is that case here?
Excuse me?
Is that case here?
The case is cited in the briefs, Your Honor.
Yeah, but is it here?
No,
We're
that
talking
was-
about this case.
That was 33 years ago, Your Honor. What we are dealing with...
Well, let's talk about this case in this year.
Well, this case
In
involves...
this year, she will hurt nobody.
That is true, but this case
So
involves...
the interest of the state is what?
The interest of the state, or I should say one of the interests of the state, as parents patriae, is in protecting someone who cannot protect herself, both mentally and physically. Susan Barnes, according to the...
Why can't she... What is there in the record that says she can't protect herself physically?
There is the
The
uncontroverted...
fact that she couldn't resist her father in yanking her in the car?
There is the uncontroverted expert testimony of Dr. Mathewson, accepted by the court below, that while in the neurotic manifestations of her illness, Susan Barnes is simply not capable of properly caring for herself. A good example of this occurred...
Like what? That's what interests me in that testimony.
Well, a good example of this occurred in late 1975 when Susan Barnes, under the influence of mescaline, walked several miles barefoot in very cold weather through the streets of Maine. As a result, she contracted a severe case of frostbite, which required medical attention, hospitalization, and surgery on her foot. Notwithstanding this, a year later, talking to Dr. Mathewson, Susan Barnes denied that the injury was a serious one at all. She also denied that the incident had anything whatever to do with her. This is a classic example of what Dr. Mathewson...
She could have been just lying, couldn't she?
I don't think we should accept that she would be lying to
Well,
Dr.
if she's lying, she has a perfect right to lie, as long as she doesn't lie under oath.
The problem there, as Dr. Mathewson saw it, was a matter of blocking. That is, she was not consciously saying, this was not a part of me. It's an unconscious thing, which is part of the mental illness, which was
And
induced
this came
in
out
Susan
of how
Barnes.
many sessions? It was about 3 of them, wasn't it?
5, Your Honor.
About 5 half-hour pieces, so.
Well, I think they were a
range
little
all
longer.
kind, you know, a real careful one. I saw nothing in there of any tests of any kind. And I assume if there had been tests, they would have been testified to.
Well, there were tests,
This-
Your Honor.
What did the test show?
The tests showed that Susan Barnes is suffering from a mental illness.
Yeah, all of those, well, those mean nothing to me when you take 100 tests and they all come out with that little catchphrase.
Well, it is more than a catchphrase because it is a very real phenomenon in this case.
Sure, she was like people that are brainwashed in Korea and
No,
Vietnam.
that was not the problem. The problem was that she is, and this goes back to that frostbite
But the
incident.
point is that she was not a danger to anybody. Now, why does the state have this uncontrollable interest in taking this woman out of society and submitting her to examination? I can understand under the police power of the state that you can take a person that's of danger to himself or anybody else.
The problem here, Your Honor, is that the state's powers which may justify a limited intrusion on religious practices, are not limited.
If you want to intrude on the First Amendment, don't you have to get a little more than a little bit?
Well, we have a little more than a little bit, Your Honor. We have here something analogous to that which the court had in Prince. In fact, we have a stronger case than Prince, for there the court relied upon the state's interest in protecting the health and welfare of minors. Yet there was no showing that the 9-year-old girl involved in that case had had her health imperiled. Here we have someone whose health has been found to be very severely imperiled.
And who is twice 9.
And who is twice 9. But nonetheless, a proper...
Which is a whole lot different.
But nonetheless, a proper subject...
Do you recognize a difference in parental control over minors and adults?
That is correct, Your Honor.
I hope so.
But that does not mean that the state does not have, in the proper case, an interest as parents patriae in
Well, isn't the parents patriae interest of the state different when the person involved is a minor and is an adult? Of course they're different.
Of course they are, but...
And we're dealing here with an adult.
We're dealing here with an adult who is as little able to competently decide for herself as would be a child. And that is why the state's interests are properly invoked, and that is why they are so strong in this particular case. Now, to turn from the state's interest as parents patriae to the state's interest in promoting the general welfare of society, we see that the guardianship also serves important state interests in that regard, because society as a whole has a stake in freeing Susan Barnes' mind from the mind control which has been exerted upon her through the coercive practices of the New Freedom Church. In other words, at present, she lacks freedom of thought, which Justice Cardozo said was the indispensable condition for nearly every other form of freedom. Susan Barnes is incapable of freely exercising the rights guaranteed her under the Constitution. She is incapable of freely choosing to participate in our society and our political system in a meaningful way.
Well, one freedom of choice she had was when the parents asked her to come with them, she wouldn't, and they had to drag her.
That was...
So she could. She could make choice, couldn't she?
The problem was the
Her
clinic...
choice was not to go with him. Wasn't that a choice?
Unfortunately, Your Honor, it was not a free choice in the sense we are talking about, because it was the product of months and years of coercive influence upon her by the New Freedom Church. In fact, she lacks the freedom of thought, she lacks the freedom of choice to act the way an adult citizen may choose to act in our society.
Suppose there was a group of young people in the community that persuaded her by example and by long argument to do a lot of things her parents didn't like, such as quitting school, such as smoking pot, such as perhaps taking a car without authority now and then. Would they have the right to, would the state have the right to intervene, assuming she committed no crimes? Would the state have the right to intervene in that case?
Under Section 3601, subsection 4, Your Honor, the state would have a right if two things would have happened. First, those persons would have exerted what is clinically considered to be coercive persuasion over her. And second, that coercive persuasion caused her to be suffering from a traumatic neurosis such as she is presently suffering from. That is what the statute deals with.
Are you reaching the conclusion that because a young person takes up with bad companions of bad influence, that the state can intervene?
No, we are not, Your Honor. But if those bad companions are so bad that what they do is lock her in a room, subject her to no outside stimuli, but only continued exhortations to do what they tell her to do, and all of the other elements which are characteristic of coercive persuasion, then the state of Maine may indeed act, and its probate court may indeed appoint a guardian for the person who has been so victimized, so traumatized, and so caused to have a mental illness that she cannot again make a free choice with her own life.
What do you say, if anything, as to Mr. Pagan's arguments that some of his clients have standing, the minister and the church?
We are not disputing the standing of the minister and the church, nor did we in the courts of Maine.
Why not?
We recognize here that among the personal First Amendment interests here are interests which the church and Reverend Connell have. There is no doubt that there is an indirect impact, although no more than an indirect impact, upon the church and Reverend Connell as well as Susan Barnes.
Well, aren't there, your opponents rely on the First Amendment, and Susan is here. Aren't there cases that say as long as Susan is here, nobody else has a right to be here?
Well, it was a point which was not pressed upon the Maine Supreme Judicial Court. And
Could it be that the Sierra case and other recent cases of ours seem to let anybody have standing, slows you down?
I wouldn't go that far, Your Honor, but it may well be that the Supreme Court's opinions on the standing area were one of the reasons that counsel in the Supreme Judicial Court of Maine did not challenge the standing of the church and Reverend Connell. Against the weight of the state interests which are served by the appointment of Jonathan and Shaleen Barnes as guardians of their daughter, we must balance the indirect burdens upon the religious practices of the appellants, all of the appellants. And the only burdens upon those religious practices are those which result from one simple fact, which is that it is necessary, in order to give Susan Barnes the treatment which she so urgently requires but cannot obtain for herself, that for a short period of time she be separated from other members of the church. It is not a controverted fact that this is a requirement of the kind of treatment which Susan Barnes must receive. Now, the burden comes from 2 points, both of which stem from that simple fact. First, Susan Barnes will not be able to worship communally with other members of the church. It should be pointed out that she will be capable of worshiping on an individual basis by herself, according to her own methods. It is also true that she will be able to believe whatever she chooses during the period of the guardianship. Second, the church loses the services for a brief period of time of Susan Barnes as a proselytizer, religious trainer, and collector of funds. Now, it should be pointed out that this is a loss which is limited in time because, as Dr. Mathewson testified, it is likely that it will take 1 to 6 months to treat her, although it may take more. Those are the numbers which Dr. Mathewson gave. And in addition, it is limited in the sense that it does not really strike at the very heart of the practices of the church. And it is further limited...
You mean if you strike at the raising the money, you don't strike at the heart of that church?
There is no evidence at all, Your Honor, that if Susan Barnes is not permitted to go out on the streets of Bath, Maine and beg that the church will go bankrupt. They may have many other proselytizers and collectors of the funds. Moreover, this intrusion is limited in the sense that it is the least restrictive intrusion possible if the state is to be allowed to vindicate its important interests in this case. It should be pointed out that we are not dealing here with involuntary commitment or voluntary commitment. In the first place, the guardians cannot, under Maine law, voluntarily commit their ward on the ward's behalf. The ward must act for herself in that regard. So under this statute,
I get great problems with a child being a ward.
well,
They're different people. They're apples and oranges.
well, she is precisely a ward under the guardianship decree which was handed down by the probate
Yeah, but I mean,
court.
so far as the parents are concerned, she's a child. I hope she's still their daughter.
She is, Your Honor, but she is also subject to the decree of the probate court, Saginaw County, and that means that the parents have responsibilities, which we must assume they recognize, to the probate court and to the laws of the state of Maine in how they conduct their affairs. And they certainly would not be allowed, under the law of the state of Maine, to go forward and commit this girl. They simply cannot do that, and they won't do it. There is no evidence at all that Susan Barnes will be committed. The treatment is an outpatient type of treatment, a talk therapy, a psychotherapy in which
Well, I thought she said if given an opportunity, she will go back to those people.
Susan Barnes said.
Yes.
That's correct, and at the termination of the guardianship.
Now you say she's not going to be held away from them?
She will be held away from them for a short period of time. She will be in the home of her parents, and her parents will presumably drive her down to the offices of Dr. Mathewson, where she will engage in this talk therapy by talking out her problems with Dr.
I thought she
Mathewson.
said first chance she gets, she's going back to the Reverend, what's his name?
Connell, if that is what she does, Your Honor, we'll have an interesting legal problem. But that is not before the court at this time.
Well, I understand under this order it is. This order says she shall be subjected to treatment.
This order says
and I would assume if it's not voluntary, it'll be involuntary.
If indeed it develops...
If it's not voluntary, I mean, if it's left up to the voluntary, what's this case here for?
Well, it should be pointed out that once before Susan Barnes...
What is this case doing here if she can walk away anytime she wants to?
This case is here because Susan Barnes is claiming that there is some sort of illegitimate restriction on her First Amendment rights arising out of the guardianship. It should be pointed out, however, that it is not necessarily involuntary treatment in the sense that is being protested, because once before, Susan Barnes saw Dr. Mathewson, and at that time she was hostile at first to the doctor. She said that she wouldn't participate in the treatment. She refused to. But somehow, when she saw that Dr. Mathewson was a supportive and helpful and friendly professional trying to assist her, she talked. That may very well happen here. We cannot presume that Susan Barnes will refuse to talk to Dr. Mathewson and will run away at the first chance she gets. Now, the intrusion upon the First Amendment interests is thus limited, and it is limited to that which is essential for the state to achieve its legitimate goals, because the state simply cannot treat Susan Barnes for the traumatic neurosis from which she suffers unless it temporarily removes her from the custody of the church. That is testified, and again, the testimony is uncontroverted by the expert witness, Dr. Mathewson. In summary, what we have here are important state interests which are vindicated by the appointment of the appellees as guardians of their daughter.
But that's not enough. Where's the compelling state interest?
Well, the interest is, I think, a compelling one, although it should be noted that there's no magic to the term compelling state interest. This court has, in these cases that is, which involve the application of a secular statute serving legitimate state goals, but which have indirect burdens upon religious practices. This court has, in these cases, used a variety of words to describe the requisite state interests. In the Gillette case, we find the word substantial government interests that relate directly to the very impacts question. In Yoder, we hear about interests of the highest order. No matter what the precise verbal formulation, I think these cases yield two important generalizations. First, the process is indeed a process of balancing carefully the interests of the state on the one hand, the interests of the individual on the other hand. Second, in striking that balance, it is true that the state or the person who is seeking to vindicate the interest of the state is required to make a heavier showing than the person on the other side of the case. We do not dispute that. Rather, we think that given the facts of this case, given the important state interest, both as parens patriae and protector of the general welfare involved in this case, that the state of Maine and Jonathan and Shaleen Barnes, as guardians appointed by the courts of the state of Maine, have given this court the requisite state interest. In conclusion, what we have here on balance is an intrusion upon the religious practices of the appellants, which is limited and which is strictly justified by the important state interests involved. If this court has no further questions, I would like to thank the court.
Gardner. Ms. Gill, since Mr. Godrich went over 3 or 4 minutes, we won't hold you to your 5 minutes.
Thank you, Your Honor. I'll try to finish in 5 minutes anyway, but I do appreciate that.
In your brother's last sentence, your opponent's last sentence, he said something about on balance. Do you have anything to say about on balance in reference to this case?
Well, I believe that we've said that in the case of religious belief, no balancing test is required. The belief is absolutely protected. In the case of religious conduct, this court has said that if the state has a compelling interest, it may be balanced against the very important First Amendment right to practice one's religion, that is, religious conduct. Mr. Pagan has indicated that the 2 major reasons that appellees put forth as a compelling state reason, the coercive persuasion and the traumatic neurosis, do not serve as a compelling state interest. Mr. Gottridge also indicated that the forceful psychiatric treatment of Susan Barnes is the least restrictive alternative in this case. And as a point of my rebuttal, I'd like to respectfully disagree. Because even if the state does have a compelling interest, a compelling justification for interfering with the church's use of coercive persuasion, as it's defined in this case, surely there are other means available, less restrictive, and placing Ms. Barnes under guardianship. I mean, in order to stop a crime, the state takes direct action against a criminal. It doesn't put the victim into seclusion for 6 months. The state in this case would have criminal restraint statutes or kidnapping statutes if it wanted to take action, as the Supreme Judicial Court said they wanted to get at the church, if it wanted to take action against the church. Better yet, the state of Maine could make coercive persuasion a crime if it's so terrible. It shouldn't try to deter coercive persuasion as practiced by this religious organization by picking off the members one by one and restricting their liberty. So we submit that there are several less restrictive alternatives that this court should consider. In addition, we ask this court now, at this moment, to take a broad view, if you would, and consider the far-reaching implications of any decision concerning religious liberty. Over the entire history of our country, as new religions and sects have sprung up, each seeming bizarre and mystifying to faiths more firmly established, have had to struggle to survive. 30 or 40 years ago, anxieties were raised by the Jehovah's Witnesses and their aggressive proselytizing. The Mormons were widely feared and despised. They were chased by state militias from one haven after another. The Quakers, the Anabaptists, even the Jews and the Catholics, when those faiths were held by newly arrived European immigrants. Zealous religious commitment is not new. I mean, it's as old as conversion itself, but it can be intensely frightening, precisely because it has the potential of dividing communities and families. Jesus said, "I have come to set a man against his father and a daughter against her mother, and anyone who loves mother or father better than me is not worthy of me." St. Francis of Assisi's father disinherited him because he refused to take over the family textile business. St. Thomas Aquinas' parents locked him in a room with a prostitute to show him the values of the secular life were better than the Dominican order that he wanted to enter. Now, these saints were the religious zealots of their day, but they, like Susan Barnes, like all human beings, they simply had an unquenchable need to make a little sense out of their lives. Every new religion begins with a community of people seeking that kind of meaning intensely together through discipline and obedience, and rejection of the temptations of the world. Now, when a young adult like Susan Barnes makes that choice and adopts a new faith, the natural anxiety and anguish felt by her parents must give way to the collective wisdom of 200 years of constitutional protection. I mean, the whole point of religious liberty has got to be that a person can make an enlightened or a foolish choice, that they can choose a conventional or a ridiculous truth. Otherwise, orthodoxy lies in the hands of government officials or in the subjective impulses of probate courts. This is the specter. The specter of this danger broods over the entire First Amendment area. Now, we turn to this court for the protection of our religious liberties. It's here that they stand or fall. And a failure to uphold the religious freedom of Susan Barnes would serve as a clear signal that this court is ready to reduce its protection of these rights. For that reason, we respectfully ask that this court reverse the decision of the Supreme Judicial Court of Maine and dismiss the guardianship decree.
Thank you, Ms. Gill.
Courtroom afterwards, so everyone doesn't stand on everyone. There is a set of stairs in the rear of the courtroom that leads to the outside, and there's double doors leading to a large space on the left here. There'll be plenty of time. The justices are going to talk to the team members immediately following the argument, so you don't have to rush over there. Take your time. Please be careful to go out and get to the rail.
All rise.
We have been out, we have talked, we have prayed, we have not proselytized, and since there was only 3 of us there, we couldn't raise any money. But we did have to do a few things, and my brothers will tell you about some of them.
Well, first I would like to say that in my judgment we have had an extraordinary performance by 2 gifted teams of advocates. This performance is not only a testament to the skills and achievements of the oral advocates, it's a testament as well to the brief writing members of the teams. The briefs were simply superb. They were tightly written, straightforward, persuasive, professional documents. And I can tell you that more cases are won with good briefs than with oral arguments. The performance here this evening and the briefs filed in support are also a testament to the level of learning that is available here at the Harvard Law School. Indeed, they are in the end a testament to the excellence of the faculty at this great institution. I could go on in some detail and critique the oral arguments and the briefs, but I know you're anxious to hear the announcement of the winners. So I'll stop filibustering and say simply, it's a pleasure to be here, and thank you all for inviting me.
I want to extend on behalf of all of the enlightened citizens of Massachusetts our thanks and our good wishes to Mr. Justice Marshall, and to Judge Wright. We're delighted to have him with us. I agree with Judge Wright, this is no time for wit or wisdom, because we have at least four elevated blood pressures right down there. And in a spirit of compassion, we want them to come down to normal just as quickly as possible. Let me just say that the contest was extraordinarily close. The performance of all four contestants and the production of the briefs and the brief writing was extraordinarily good, and I, for one, feel privileged to have participated with you all. Thank you.
Well, I have a little dissent on what my brother, Judge Wright, said about the faculty. I don't know whether you heard this story or not, and if you did, I'm going to tell it anyhow. About this young person, man, woman, or child, who went through this law school and only went to school 3 days and took his exam at the end of the year after much argument. And late in August, he happened to be coming through Cambridge, and he stopped by to see what happened. And he told him his name, and they said, well, wait a minute, the dean wants to see you. And he said, I don't know why. So he went in, the dean said, are you the guy that was only here 3 days? No. He said, yeah. He said, well, I just can't understand it. He said, what? He says, on your exams, we've weighted them, and we've marked them, and you have a mark of 97. And we just can't understand it. And the guy said, I can't either, let me think. Oh, I know. It was those 3 days I went to school. Having made my last trip to Harvard, I will tell you that these moot courts are great, so far as I'm concerned, because of their importance. And that's why I'm particularly happy to see so many over, because, as both have said, it's important to these people. And I know how much time they put in it, and how much sweat, and how much argument, and how much everything just short of fisticuffs that go in writing a brief and preparing for the argument. And my thanks are all four involved and the others that worked on the briefs. I don't know what order these should be announced, but we had 3 jobs to do. And number 1, the best oral presentation was by Ms. Sheila Kuhl. I have been told by my associate here that at least we've got the women vote here. Huh? Yeah, I got it. And for the briefs, the appellees had the better, and there's no question that the award for the best briefs go to this side here. Our final chore was to pick the better of the two sides, and we picked the appellants. I might confess to you that we were all three, I have participated in these before, but this is the first time we had applause while the arguments were going on. And you outfoxed me. I didn't know what to do. And I hope it won't be done the next time we have these arguments. But as I look back on it, I think it was very good that we allowed you to warm up so that you could applaud the court. Thank you very much.